I think I'd be very confident on that. I suppose there are a couple of questions. One is, I think it's been suggested from some of the submissions, but the direction of travel at the criminal bar, and the same question applies to solicitors, if it's affecting as well. Are we seeing, and anecdotally I see that said that there's a drop-off of people practicing crime? Either people don't go into it, full stop, or if they go into it, they don't stay in it, or they have a mixed practice for a number of years. And then, I think that traditionally now there may be an impact with the CCJ being a little bit away from the forecourts as well. I'm told in days of old you'd run from a jury trial to a defamation trial and back again. Both have juries, or keep juries if this committee is its way, but that's a separate, maybe a separate point. But so I know there's maybe a separation there now, but down the on circuit that would not be the case, because obviously civil and criminal are going on upstairs and downstairs and everything else. But is that, I suppose the question is to all the witnesses or all that want to comment on this, to what extent is that seeping through to practice? Is that really having a detrimental effect on the numbers available to take instructions, be that defence or prosecution? That's the first question. Maybe let's start with that, actually, because I have a couple of other questions. Mr. Morrin, and I know you haven't got in yet, so I'm going to take you, yes, and then I'm going to take Ms. Phelan, and then anyone else that wants to comment. Mr. Morrin,
I can speak from lived experience in relation to this. I no longer practice in criminal law,
right,
because it's just not economical for me to do so.
Okay.
We've been discussing the restoration of fees. The problem is efficiency as well. If you go down to the district court, barristers in the district court provide the efficiency to generate the cases through the courts, starting like triage in the district court. But if barristers are not getting paid, like myself, or not getting paid enough, they're leaving. I've left.
Or not getting paid at all.
Or getting paid. Hands up, I've had to threaten the revenue on a solicitor firm because they wouldn't pay me. So my lived experience is barristers cannot afford to stay in the district court. And you're right, if it was in the forecourts, and anecdotally I've been told, you would get briefs of colleagues who would hand you a brief because they were too busy. But they separated it, we're all in the CCJ or the forecourts, and you don't get the handovers. So it limits the amount of earning potential that a young barrister can have.
For mixed practice.
So, like, what other profession would have a barrister leaving the forecourts and going down to a restaurant to work as a waiter or a waitress or a bar? And that's the reality for these. I was blessed that I have a pension from another profession, that I can afford to stay. But even at that, it just became, my pension was subsidising the free legal aid scheme because I was working in the district court for nothing. So it's just not tenable. And I see, taking head 19 of the bill, section 7, where a solicitor could make a written application for counsel. It could, if that written word was taken out, he could make an application to court for counsel in the district court, because there's not enough criminal solicitors practicing. I got a text last night from a criminal solicitor who's given it up. It's uneconomical for him. So they're having a problem. They're using barristers to shore up their offices.
Is it affecting both professions? Yeah,
exactly. Most definitely. Most definitely. But if they could make an application for barrister to the court, oral application, and the barrister gets paid directly by the system,
under the proposed scheme,
we would solve the problem.
Yeah, absolutely.
Thank you, Chairman.
Thank you very much. I'm going to go